Good afternoon, everybody. Welcome to this FTB webinar, fairly short notice webinar about the Epping Forest asylum seekers case. Obviously, a case of great topical interest, and I imagine was already generating a lot of work and queries for you. We hope we can be of assistance in letting you know what's happened and some of the future implications. I'm presenting this today. I'm Andrew Fraser-Urquhart, King's Counsel. And I'm presenting this with Charles Forrest, who is a junior, called in 2014, so not as young as he once was, already on the Treasury C panel of counsel, and I've led him on a number of occasions. In particular, we did a lot of litigation for TfL in securing injunctions against road protesters. We've also done a low traffic neighbourhood case together in front of Mr. Justice Eyre, who was the judge in the Epping Forest case. So we know him well. We're going to present now some slides, which Charles is going to put up, I think. Brilliant. There's our ugly mugshots. And then just as a very general introduction, I'm sure most of you who've not been living under a rock this week will know most of this. This is a case obviously concerning the Asylum Seekers Hotel in Epping, the Bell Hotel. There's been so much press comment about this case and political comment. I should first of all perhaps say that this is not in any way a political discussion. This is purely a legal analysis of what the case did and did not say. As I say, there's been an awful lot of much misinformed comment. And this was really a case about an alleged material change of use of a hotel to either a hostel, as some have sought to describe it, or a sui generis use where it was occupied solely by asylum seekers. And we'll look at the facts of that in a little bit of detail in a moment. It was an application for an interim injunction in an application which of itself was solely for an application under section 187B of the Town and Country Planning Act for an injunction. And contrary again to some speculation, that no enforcement notice had been issued. So it was a case where the local planning authority went straight for an injunction. The form of relief, the case was only decided on Tuesday. And in fact, I think the final form of relief, as takes just a little time in the usual way of things with drafts going to and fro, may not yet have been finalised. And certainly we haven't seen it, but the expectation is that there will be a requirement to, in fairly short order, bring to an end the breach of planning control, which in effective terms means that the asylum seekers will need to be moved out from that hotel and accommodated elsewhere. This was a case involving an exercise of discretion, and the judge went out of his way to say that the case was acutely fact sensitive, and we'll look in a little while at why that is so. And he also went out of his way to say that there were absolutely no general rules or presumptions about whether or not an injunction, an interim injunction, would be granted in a case such as this. And as I'm sure many of you will know to your discomfort already, there's a great deal of political pressure now coming. Some of you, I suspect, will receive or will have received instructions to proceed with your own injunctions, come what may. Others will be being asked for legal advice as to exactly what the case says and means, and we hope that we can help with that. Now, in terms of the structure of our talk today, what we are proposing to do is this. Charles, I'll hand over to in a moment, and he will take us through the principles and procedures for planning injunctions, just so that we can all understand clearly exactly where the law is about the process that's being used. I will then take you through the details of the Epping case itself, Charles will then tell us about some of the other asylum cases, because you'll probably know that there have been 3 or 4 of these cases already decided in different ways, and we'll try and illustrate for you some of the differences to help you understand your own situations. And then finally, I'll talk about some of the implications of this case going forward, and as to how it might impact advice you've got to give immediately, if not sooner. So, Charles, to you now, please.
Thank you very much, Andrew. So yeah, so I'm just going to, before we come on to the specific cases, talk about the actual sort of the power that was used and that can be used for any local authority that's going to be making its own future application. Obviously, it's vital to understand the section and the procedure for that purpose, and also to understand Epping and the other cases. I'm sure some of this will be familiar to some of you, but I know many authorities don't use injunctions particularly often. So either way, I hope this will be some helpful background and helpful grounding. So we start obviously with the wording of section 187B itself. It's a short section, and subsection 1 provides where a local planning authority consider it necessary or expedient for any actual or apprehended breach of planning control to be restrained by injunction, they may apply to a court for an injunction whether or not they have exercised or are proposing to exercise any of their other powers under this part. So just to pick up on a few points there, it's a power that belongs to the local planning authority, not to anyone else. It is in addition to other powers that local authorities have to bring proceedings or injunctions. So, for example, Section 222 of the Local Government Act, Section 1 of the Localism Act. So there are various powers available to local authorities, and this one is additional to those. The next point is actual apprehended. Obviously, most local planning authorities have a whole panoply of enforcement powers available to it: enforcement notices, stop notices, breach of condition notices. Most of those are in relation to breaches which have already happened. The powerful thing about a Section 187B planning injunction is obviously it can be used in those circumstances, but it can also be used in respect of apprehended breaches of planning control, i.e. ones that have not yet happened. They're anticipated, they're going to happen, but they haven't yet happened. And that wasn't the case in Epping, or if there was indeed a breach of planning control, but in all the other cases, they were effectively apprehended, what's called a quia timet injunction, where you're seeking to restrain something which you expect to happen but hasn't yet happened. So that's an important feature of the power in this context. An injunction, obviously, that means, unlike other enforcement powers, it's not the local planning authority issuing a notice unilaterally, as it can do with an enforcement notice or a breach of condition notice or a stop notice. The authority has to go to court and has to ask for an injunction, and obviously we'll come on to the principles that the court will apply in deciding whether to give the local planning authority the injunction that they seek. In terms of what court you're going to, well, you can either go to the county court or the high court. In almost all circumstances, local planning authorities go to the high court because you want generally you want an inter-injunction, and that means you have to apply the American Sinamid test. So generally, local planning authorities, although they can go to the county court, they more often than not go to the high court. And then the final bit, which is whether or not they have exercised, they can apply for this injunction, whether or not they have exercised or are proposing to exercise any of their other powers under this part. Sometimes a local planning authority will serve an enforcement notice to begin with. That won't be complied with, and so they'll then apply for an injunction to enforce that. Other times, an authority will go to an injunction in the first instance. Either option are perfectly permissible legally, but obviously what the authority have and haven't done may well be relevant to whether the court will grant the injunction or not. And we'll touch on that a bit more detail later on in the talk. So what's the procedure if you're a local planning authority and you're wanting to apply for a planning injunction? What procedure do you use? You use the Part 8 procedure as distinct from the Part 7. So Part 7 under the CPR is what you generally use in civil proceedings, and there's a very elaborate sort of scheme of pleadings and disclosure and evidence serving and things like that. The Part 8 procedure sort of bypasses much of that. It's a summary procedure, and it's used for where there isn't expected to be any real disputes about fact. So when you're using the Part 8 procedure, which you must when you're applying for a planning injunction, and this is good news, by the way, for local authorities, because it means that it's less burdensome, it's much quicker, and it's generally easier to bring a Part 8 claim procedurally than a Part 7 claim. You will file and serve your claim form. Together with that, you'll file and serve your details of claim. That's your equivalent of a particulars of claim in a Part 7 action. If you're looking for an interim injunction, which you often are, and all the authorities in the cases that we are going to be discussing today, we're all seeking interim injunctions. You need to apply for it. So you file and serve your N244 application notice. You will Part CPR Part 25 contains the information you may want looking at interim remedies such as interim injunctions. Obviously, because you're looking for an injunction, you're filing and serving a draft order, sort of showing the terms of that injunction, what will be prohibited or required by it, and that draft order will contain a penal notice, so that the recipient of it knows that if they don't comply with the injunction, they are at risk of being committed to prison. And obviously, there are many benefits of an injunction over other enforcement remedies, such as you can deal with apprehended breaches, like I said. But another one is obviously that, unlike those other enforcement procedures, it has more teeth, essentially. If you are able to get your injunction, unless the recipient of that injunction complies with it, they are liable to be subject of committal proceedings, and that could mean prison. So it's a powerful remedy, and that's why it can be so useful. But in order to sort of be procedurally fair, your draft order will have to include a penal notice, which says, if you disobey this injunction, you're liable to be committed to prison. And then finally on the slide, we've got your evidence. Again, like I said, it's a much sort of slimmed down procedure compared to Part 7. So you're serving your evidence as a local authority applicant, as a local authority claimant. You're serving your evidence at the same time, filing and serving your evidence at the same time as your claim form and your details of claim. And so what would that evidence be? Well, it will be witness statements from, in this context, planning officers, perhaps environmental health, perhaps councillors, people like that. But you'll have a witness statement or witness statements with exhibits. And then when it comes to the hearing, it's likely that the evidence will all be written. It's likely there won't be any oral evidence or any cross-examination. Consistent with the sort of slimmed down procedure, evidence will be in writing and will be adduced on that basis and accepted by the court on that basis. So that's the procedure of how to apply for a planning injunction. In terms of the principles that will be applied by the court in whether they're going to grant you such an injunction, the two most important authorities are South Bucks and Porter, which is a House of Lords authority from, I think, 2003 or 2004. And then Ipswich Borough Council, which is actually an asylum seeker case, and one that I'll be talking about a bit later. But if you are sort of new to this procedure or need a refresher, the two best authorities to read would be these two, and obviously Epping, given it's the most topical. But for the sort of fundamental nuts and bolts of the procedure and the principles to be applied, it's those two at the top of the slide, which I'd urge you to read. In terms of how the court will apply its discretion, an important point is that it has an original jurisdiction. It's not supervisory. So the court is not going to be sort of gloves on, light touch in a way a judicial review may be, where the court will sort of very much respect the discretion of the local planning authority. There is an element of that, of course, but the court's jurisdiction is original. So your defendant, if you're applying as a local planning authority, the defendant can resist your application on sort of legal judicial review grounds, or indeed any other grounds. The court's power to grant an injunction is discretionary. That's clear on the face of subsection 2. The court may grant an injunction, and that discretionary nature is also bound up in the fact that obviously an injunction is an equitable remedy, and so it's always subject to the court's conscience, and it has a wide discretion as to whether to grant it. That discretion must be exercised judicially. So the court doesn't have an unlimited discretion. It has to exercise it having regard to the purpose of the planning injunction power, which is obviously to enforce planning control, to curb abuses where they happen, and to provide urgent remedies where urgent remedies are called for. So the court will have a very wide discretion. The defendant will be able to oppose the application on almost any basis, but the court's discretion will be guided by the purpose of the power, which is to remedy breaches of planning control, and to do so summarily where that's appropriate. The court will decide whether it's just to grant the injunction, again, consistent with this equitable jurisdiction. And they'll also obviously have at the forefront of their mind whether something is proportionate in human rights terms. And this will often be, most relevant in cases, for example, gypsy and traveller cases where you're dealing with people's homes and where there are, Article 8 considerations and Article 4 and considerations like that. So the court will have at the forefront of its mind whether the grant of an injunction is just, and whether it is proportionate in human rights terms, and whether a fair balance has been struck between the general interest, the public interest, which is the enforcement of planning control, and private interest of the defendant in any such application. And it follows from all of that, follows from everything I've just saying, that the court will consider the defendant's personal circumstances. So if any hardship will result from the grant of an injunction, the court will very much have that in mind. Last slide from me on this particular part of the talk. In terms of other considerations the court will have regard to, well, I've touched on the first one there, the need to enforce planning control in the general interest. The court will also have regard to the degree and flagrancy of the breach of the alleged breach of planning control. The court will also have regard to whether conventional enforcement measures, by which I mean sort of enforcement notices, breach of condition notices, things like that, the court will have regard to whether those have been tried and whether they've failed. And as a very sort of general statement, and this is only a general statement, if you've tried other enforcement measures and they've failed, it may well be easier to get an injunction, because you can say, well, listen, we know that this is an intrusive remedy, but we have tried the other powers available to us. They haven't worked. The defendant is not complying, and so we now come to the court seeking an order on that basis. Generally, you'll have an easier time if you've used other enforcement measures and they haven't worked. But having said all that, sometimes there is a need for an urgent remedy, such as an injunction in the first instance, and where that's justified, the court will very happily grant an injunction, even if you haven't tried other ones. So it all basically depends on the circumstances. Other important considerations are whether the defendant has played the system in order to prevaricate and delay. Obviously, we all know that some people do that. They'll try and use every trick in the book to sort of delay and deny and prevaricate. So the court will take that into account. They'll take into account health and safety considerations, and they'll also take into account the fact that it's the local planning authority, not the court, who are charged with controlling development management and enforcement. The local planning authority is democratically elected and publicly accountable. So the court will show some respect for the status of the local planning authority, but the local planning authority has to do its own, in order to sort of earn that respect, the local planning authority has to do its own sort of due diligence in terms of considering for itself many of the things that I've been talking about in terms of personal circumstances and things like that. But as long as the local planning authority has gone about it the right way, as long as they've considered the issue in detail, considered the implications of the grant of any injunction, then the court will respect its status as an accountable and democratic body. And obviously that was touched on in the Epping case. And finally, issues of planning, policy and judgment are obviously matters for the local planning authority, not the court. But the court, again, will be able to sort of have regard to simple things like how visible development is from a certain space. They'll be able to make judgments on that. But otherwise, matters of planning, policy and judgment, the court will leave to the local planning authority. Over to you, Andrew.
Thank you, Charles. No, that was a very helpful summary of the principles underlying the grant of an injunction, a final injunction through Section 187B. It's important perhaps to say right at the outset of considering this that I will deal with the principles dealing with interim injunctions shortly, but it may be of value to you in advising your members that these injunctions are aimed only at the operator of the hotel who is actually committing the breach of planning control. They're not directed, for example, at the Home Office, who obviously operate the policy of housing asylum seekers in hotels. They're not even, in the Epping case, certainly aimed at the contract holder with the Home Office, an organisation in this case called CTM, who had a large contract with the Home Office to place asylum seekers and chose to use, amongst many others, the Bell Hotel. So it's worth just bearing in mind that that's the overall framework. Now, in terms of the facts, Charles, I think you skipped on a slide. If you could go back one. Thank you. No. There we go. That one. Facts of Epping. There we go. Thank you. The hotel in question, as I'm sure you will know if you've not been living under a rock all week, is the Bell Hotel in Epping. Now, it's one of the illustrations of just how fact sensitive these cases are that the judge sets out in his judgment a very detailed factual summary, including, for example, the fact that the Bell Hotel is on what he described as the sort of inner outskirts of Epping, and its relationship to the main shopping areas and population centres of Epping was all considered. Had 80 bedrooms, had been opened in 1900. Now, it had been used as a hotel until the pandemic, but it is quite important to note that it was not a particularly successful hotel, to the extent that in 2006, the owners made an application for part demolition and for change of use to a care home. So it obviously wasn't making much of a mint as a hotel, and it closed completely at the beginning of the pandemic. It was then used in 2020 to 21. You'll remember that at the outset of the pandemic, there was that policy of accommodating all homeless people somehow, some way. And it was used for that purpose for a few months. It then had a very brief life as a hotel again, August 22 to October 2022, but again effectively failed as a hotel. Used again for asylum seekers for about 18 months after October 2022, then closed completely for another year, and then the current use began in April 2025 under the CTM contract. Now, emphasize those facts because clearly, on the balance of its history, it had been a long time, a very long time, since it had been used as what one would understand traditionally as a hotel with normal paying guests and so forth. Now, the situation in terms of its planning history, next slide, please, is it was contracted to accommodate 138 asylum seekers. The hotel continued to provide some facilities that one would associate with a hotel. So, for example, a reception was manned, there was catering provided, and the rooms were cleaned by cleaning staff employed by the hotel. There was a security presence which was provided by CTM, and the residents, the asylum seeker residents, were under considerable restrictions actually as to their liberty. Although they were free to move around as they wanted, they had to sign a register every day, and if they wished to be absent from the property overnight, they had to get specific permission and authorization from the security presence. They also had no choice of the rooms to which they were assigned. And of course, you'll see from the numbers that they were doubling up in most cases. And rather charmingly, the judge noted that they weren't in a position to apply for an upgrade of a room, even in exchange for payment. Now, in terms of the planning situation, the council, from the outset of the use for asylum seekers at all, which was not just under the CTM contract, but from the outset, the council objected and indicated that they thought that the use represented a material change of use. And in fact, in response to that, the owners made an application for a temporary change of use. But there was then obviously some degree of shenanigans went on because the application for temporary change of use was withdrawn, apparently after the Home Office came in and assured the operators and owners that the Home Office's view was clearly that there was not a material change of use. So that was the essential factual scenario. Next slide, please. The framework, the legal framework under which this is all done, is it was an application under Section 187B, as Charles has described. There was, in this case, no enforcement notice changed, and the allegation that the breach of planning control, actual breach of planning control, was a change from C1 to either a hostile use, which is now regarded as sui generis, or indeed, in fact, the proceedings described the change of use into a new sui generis use described as accommodation for asylum seekers, but in any event, a material change of use. The judge obviously set out in detail the Section 187B principles that Charles has outlined for us. But of course, we're dealing here with an interim injunction, and that is the principles for interim relief, as you'll probably remember, are set out in that wonderfully named case, American Cyanamid, which is a House of Lords case from the 1970s, which sets out that where you have an application for interim injunctive relief, the things that you essentially have to consider are, first of all, whether or not there is a serious issue to be tried. That test is formulated in a number of different ways: arguable case, good arguable case. The words of American Cyanamid, a serious issue to be tried. Secondly, whether damages would constitute an adequate remedy in the event that the matter proceeded to trial without injunction, that whatever harm was being caused would be sufficiently compensated for in damages. And if that's the case, you won't get an interim injunction, because if things go in your favour eventually, well, you'll just get extra damages. And that is usually, certainly in private law, between private law parties, is dealt with on the basis of a cross undertaking in damages, whereby the person seeking the injunction will have to give a cross undertaking that if they fail in their eventual action, they will pay damages to the party whom they were suing but failed against, on the basis that those damages will compensate the injured party for the loss that it incurred by virtue of having what turned out to be an unjustified interim injunction imposed upon it. Now, again, as you will probably all well know, the view has been taken as a matter of public policy that local planning authorities seeking to secure an injunction and even an interim injunction in support of the general good should not be required as a matter of policy to provide a cross undertaking in damages. Now, that has a slight gloss in this case that we'll come on to, but as a general rule, a cross undertaking damages is not required from a local planning authority seeking an interim injunction. And then when those factors are all considered, the matter comes to what's called the balance of convenience, and the judge has to make a discretionary judgment as to whether the public good is best served by making the interim injunction or not. And it's those balance of convenience factors which are at the heart of this Epping case, as we'll see in just a moment. Now, a couple of other considerations that the judge initially wrestled with, again, really going to this point about balance of convenience, is whether or not the local planning authority could have simply used a stop notice. Well, that wasn't on the planning history open to the local planning authority because the asylum seeker use had begun more than 4 years ago. It didn't matter, as the legislation clearly says, it doesn't matter that the use is not continuous. It simply had it occurred more than 4 years ago as it started up, and so a stop notice wasn't open to them, and the judge took note of the time that it would take before either conventional enforcement notice proceedings could be determined, which would be several months, if not stretching into a year, 18 months plus, when the possibility of appeal is taken into account, or indeed Section 187B proceedings themselves. The earliest the judge reckoned that one would get on would be sort of late autumn. I've heard whispers that it would be October, but in any event, some considerable time for harm to be continuing. So the next set of issues to be considered are some general points. The counsel for the defendant hotel operator accepted that there was a serious issue to be tried. So then it was really a matter of the issue of adequacy of damages, which was again accepted not to be adequate in the sense that the harm, and we'll go on to see what the evidence showed the harm actually was, of the existence of this asylum seeker hostel in breach of planning control. Whatever that harm was, it certainly isn't something that could be compensated for in monetary terms. So again, that wasn't an issue. As I said, cross-undertaking damages doesn't arise for a local planning authority anyway. So then it was really the balance of convenience factors. And one very important point that the judge made, which comes out of the Ipswich case, which we've touched on, and Charles is going to talk more about the facts of in due course. But one of the very important points that was made was that the factors relating to the balance of convenience had to be factors which were relevant to planning law. They had to be planning matters. Now, as we'll see, that's quite a flexible concept, but it is very important to note that factors which have nothing at all to do with planning, which obviously in a politically charged issue such as this, it's conceivable to see how people would think of things which they think are relevant, but in fact have nothing to do with planning, they can't be considered. The factors related to the balance of convenience must relate to planning, and that's very important. The second general point to make, and this is a thread which runs through a lot of what's going to be said next, is the importance of understanding the state of the evidence which is brought before the court at this interim stage. In Epping, the only evidence came from planning officers setting out in witness statements things that they had seen, observed. A lot of the information in those statements was actually derived from press reports. And the court was very keen to say that you had to have really careful regard to the limitations of that evidence. And for those of you, and we'll touch on this at the end, thinking about how you might bring forward your own applications, be very aware of the importance of the quality and the nature of the evidence about the alleged harms, about the things which fall into the balance of convenience when you formulate your cases. So the general points relied upon by the court were the importance of maintaining the integrity of the planning system by effective enforcement. That was put first in the judge's list of considerations. The second was the approach taken by the defendant, in that the judge, the council suggested that this was a flagrant breach of planning control, and that the defendants knew perfectly well what they were doing, and that, as Charles has said, gaming the system. There was an undercurrent to the council's submissions that was what the defendant hoteliers were doing. Not so, said the court. It was said to be a deliberate breach, in that the defendants knew perfectly well that the council took the view that it was a breach of planning control, but it was accepted, not least because the Home Office had told them so. It was accepted that the defendants themselves thought that they were acting lawfully, but they acted deliberately, knowing that there was at least a possibility that the council would be right, and the court would find that there was a breach of planning control. Another factor which was taken into account was the financial effect on the defendant. Now, that's not the same thing as saying that the council needed to provide a cross-undertaking in damages, or that damages would be an adequate remedy, but it was recognised that one factor operating against the grant of an injunction was the fact that the defendants would suffer financial harm. They wouldn't be able to keep making the money, bluntly, they were making by accommodating the asylum seekers. So those were some of the general factors. We'll now look on to the specifics, please. Next slide. First thing, and slightly unusually, the first thing that the judge did go into in a little bit of detail was the strength of the claim. And one of the reasons, as we'll see, that he decided that the balance of convenience favoured making the interim injunction was the strength, as he saw it, of the claim. Now, against the fact that there was a change of use, because remember, it's a two-stage process. There has to be both a change of use, and then that change of use has to be material. So in terms of whether or not there was a change of use, against that were the fact that there'd been no internal or external changes to the building, the fact that there was some security fencing provided when the protest started, that was regarded as not connected to the change of use as such. The fact that there were still staff of the hotel in there providing services of cleaning and catering and so forth, reception. So those were the things which militated against there being a change of use. But the judge took the view that they were outweighed by a number of other factors. First of all, that the only type of occupant in this case were single male asylum seekers. Again, we'll see in other cases where there are asylum seeker families, the considerations might be different. But in this case, it was an accommodation just for single male asylum seekers. The whole building, the whole hotel was used for that purpose. There were no normal paying guests thing that had been taken over lock, stock and barrel. The occupants, as I've mentioned in the factual summary, had no control over where they went. They couldn't upgrade themselves. They had to be given the rooms, take the rooms they were given. Importantly, the occupants weren't paying themselves. This was a block contract. CTM were paying the hotel directly in a block, rather than each individual being given money and then using that to pay for a room. The asylum seekers didn't have anywhere else to live. It's not as if they were coming from their own home and being accommodated in the hotel because they wanted to be in a hotel for whatever reason. They had nowhere else to live. Their movements, as I mentioned, were controlled, and none of the facilities of the hotel, so the the bar that was once at the hotel, the restaurant that was still providing meals for the asylum seekers. None of that was available to non-residents, to normal members of the public. And they were all factors which the judge said meant that there was a powerful case, and I think he did use the word powerful case, that there had been a change of use. And the nature of that change of use, combined with the fact that, as I said, there was no use by the wider community of any of the facilities of the hotel, the ability of the hotel to provide that had gone entirely, and equally that the residents of the building now, the asylum seekers, weren't in a position to make any sort of material contribution to the community in the way that a normal hotel guest who was coming as a tourist or to do business or whatever it might be, they could make a contribution to the wider Epping community. That, said the judge, wasn't there at all, and he thought that that was sufficient to indicate that the change of use not only had occurred, but was a material change of use, therefore obviously giving rise to the need for planning permission. So those were the factors that the judge, really took into account. Now, the next set of factors in the balance of convenience, I call them the media darlings. These are the ones that have attracted all the political and public interest. The existence of lawful protests. Well, the judge took the view that lawful protest could have an effect on residential amenity. That was how the existence of lawful protest could be said to have an effect on amenity and therefore be capable of consideration within the balance of convenience. But he explicitly said it should be given limited weight, and that was even more so when the unlawful activity in support of protests and the consequent reaction by way of provision of police and security and so forth, general disturbance. He said again that was capable of being a planning matter which could be taken into the balance of convenience, but that should be given very limited weight. So, bear in mind, for everything that you've heard said on the media about, oh, well, it was because of the protests and so forth, absolutely not. They were factors, yes, but limited or very limited weight actually attributed to them. Fear of crime. Now, this is a bit of an old chestnut in planning law, as we probably know. Generally, fear of crime simpliciter is not of itself a matter of planning law, is not a material planning consideration. If it is based on actual evidence, and there is therefore some reasonable basis, as the law says, it may be given weight. Now, in this case, the actual evidence of criminal activity was limited in the evidence provided to the court by reports recorded by planning officers in their statements of evidence or of reports in the press about the 2 or 3 arrests which you'll be familiar with from the media coverage. But in those circumstances, given that that was the state of the evidence, that was the limited nature of the suggestion that there was a fear of crime based on some reasonable basis, that was therefore given, again, very limited weight. So contrary to everything else you may have heard, that was again a factor, yes, part of it, but of very limited weight. And the other factor that the judge relied on in considering these matters is that because the defendants had chosen not to make a planning application, they simply waited for enforcement action, they hadn't had a chance, therefore, to ventilate all these matters, to really examine the issue of whether or not there was a harm to amenity, to propose conditions to control the activities and so forth. And that fact that they hadn't taken that chance to use the system to get a more robust system of controls in place was something that the judge put some weight upon in coming to his overall conclusion. But when you look at what the judge finally concluded on the balance of convenience, next slide, please. It's interesting that the judge is extremely explicit about how he's done it. He said very clearly that the three main factors he was relying on were the protection of the integrity of the planning system, the nature of the breach, the fact it was deliberate and that the owners knew there was this possibility, and the strength, as the judge saw it, of the case against them. So although he explicitly says, I'm not determining whether there's been a change of use, he said, I think there's a pretty strong case that there has been. And they were the three main factors that the judge relied upon when deciding that the balance of convenience favoured making the interim injunction. As I've indicated already, he did give limited weight, but it's very important to note limited weight to these other factors about protest and fear of crime and so forth, and really only gave any weight at all, in fact, in his balancing exercise, because there was some evidence that there had been actual harm. The main thing he saw against the grant of injunction was the fact that he was aware that there was a need to accommodate asylum seekers. But those three main factors he identified made him conclude eventually that the risk of injustice, as he puts it, was greater if the interim injunction wasn't made. And so he made it. So that's really how the Epping case unfolds. We know that there are some other contrasting decisions, and Charles is going to tell us about those now.
Yeah, thanks, Andrew. So just before Andrew sort of ends discussing wider implications, I'm just going to go through three other cases, semi-recent, from 2022, all decided within a few months of each other, all decided by Mr. Justice Holgate, now Lord Justice Holgate. To sort of, I'll go through these and then point out some similarities and differences and do a bit of a wash up at the end, taking a broader view. Now, it's important to know about obviously the Epping case that we've been talking about, and also these three other cases. If you're thinking about making an injunction, it's important to know these cases and know them well. But a health warning, yeah, and it's been touched on a few times already during our talks, which is essentially there's a limit to how much can be taken from other cases, because the court has this wide jurisdiction and discretion that I spoke about at the beginning. That's the nature of the Section 187B power. Yes, it's limited, of course, it has to be exercised judicially and having regard to the purpose of the power. But the terms of Section 187B and the nature and its equitable nature means the court does have a very wide jurisdiction and discretion. The court have commented on the fact that there are cases will throw up variable facts. There's also, as Andrew said about what Mr. Justice Eyre said in Epping, he said that whether to grant an injunction is acutely fact sensitive. There's obviously all of these cases, these asylum seeker accommodation cases, they'll all relate to the breach of planning control will be whether or not there's been a material change of use. As we know, that's obviously a matter of fact and degree. And often the argument will be whether a hotel has been changed to, a hostel or sui generis for asylum seeker, whatever you want to call it. But whatever you label it as, Mr. Justice Holgate in Ipswich says that distinction between hotel and housing asylum seekers is a very fine one. And obviously, again, all of these decisions are interim remedy decisions. So, there would have been less evidence, less argument. So although it's really important to know these cases and know them in detail, one has to realise that there should be a health warning. Every case will be different, and every case will be determined according to its own facts in the court's wide discretion. So these three cases, Ipswich, I'm going to give spoilers and just tell you what the outcome was before I go through them. Ipswich was a case where the injunctions were not renewed. They were granted on a ex parte basis. They then came to be renewed a few weeks later and came before Mr. Justice Holgate. He did not renew them. Same in Fenland. Mr. Justice Holgate did not grant the interim injunction that was sought there in respect of asylum seekers in hotels. And then the final one is Great Yarmouth, where the injunction was renewed. And so I'll be discussing that one as well. I'm conscious of the time because we've only got 10 minutes left. But the case of Ipswich, as I said, interim injunctions were granted without notice. So these are two cases, the Ipswich cases, two joined claims. But in the first one concerning Ipswich Borough Council, they had served a temporary stop notice. That wasn't possible in Epping, but Ipswich had served a temporary stop notice, albeit just before making the Section 187B application. Ipswich is as I was sort of saying earlier, it's a fantastic authority to get to grips with because it has a brilliant summary on the Section 187B law. It also has great summaries of the law in relation to the Secretary of State's duties to house destitute asylum seekers, about the law on material change of use. Obviously, it's a basic component of the planning system, but as often with these basic questions, they can often be quite complicated. And so Miss Justice Holgate sets out a brilliant summary of the principles to apply to material change of use. And he also sets out the law on the distinction, what he calls the fine distinction between hotel and hostel use, or hotel and sui generis asylum seeker use. And Miss Justice Holgate says that the nature and extent of the planning harm was, in the case, relevant to planning consequences, showing whether there had been a material change of use. So that the nature and the extent of the planning harm is extremely important if you're looking to bring one of these applications yourself. That planning harm was also relevant to the seriousness of the breach and the urgency of bringing it to an end. And Mr. Justice Holgate sets out really a key question in interim cases like this, which is, would the immediate restraint of the proposed use by the injunction, rather than the use of other enforcement action, be commensurate with that harm? And in particular, relevant to that question about whether it would be commensurate is whether there would be any irreparable harm if an injunction were not to be granted. Andrew discussed sort of the fact that a court will only be taking into account sort of planning considerations, and that can be quite a wide category, as Epping showed. But one thing that certainly isn't relevant are things like the merits of the claims of the individual asylum seekers in the hotel. That is an irrelevant consideration. The court won't take it into account. In this particular case, the local planning authority had failed to evidence that there was sufficient harm or irreparable harm. The Ipswich in particular relied on the fact that the Novotel, which is the biggest hotel in the town, the loss of it would harm the town, because it means that you don't have tourists in there or something who are going to be contributing to the local economy. You're going to be having asylum seekers who are by definition destitute, and so they're not going to be able to spend money, and that's going to harm the town. That Holgate sort of didn't place much weight on that. He said that the loss of the hotel would be temporary only, so there wouldn't be sufficient harm, there wouldn't be irreparable harm, and on that basis among others, we don't have time to go through it in too much detail, but on that basis among others, he refused to renew the interim injunctions. One then has Fenland. Again, this is a quia timit. It's an anticipatory injunction seeking to restrain a material change of use of a hotel. The without notice injunction was refused, but by the time of the hearing, asylum seekers had been moved in to the hotel in question, and 20 of the 21 living there, 5 had absconded. And the issue in this case was the local planning authority essentially weren't able, or failed to, Andrew spoke about how important the evidence is, even at an interim stage. They basically, all their arguments for this harm, they couldn't support with evidence. So they were talking about risk to the asylum seekers themselves in terms of trafficking and exploitation. The local planning authority were unable to really evidence that risk, that it was a sufficient risk. The council tried relying on social tensions, the kind of tensions that we sort of saw in Epping, albeit only very limited weight was placed on them. In this case, the council tried to rely on those, but because it was an anticipatory injunction in relation to an apprehended breach of planning control, or effectively an apprehended breach of planning control, there wasn't the sort of evidence or the factual background that there was an Epping. In Epping, obviously, you had the protests, you had the measures taken in response to it, you had the arrests, and so there was sort of a broader sort of, or there was a better evidence base for that to be taken into account, albeit very limited weight placed on them. But in this case, Fenlon, it was merely really assertion of sort of social tensions. And the court sort of said, well, there's nothing behind this, it's mere assertion. Fenland also tried to rely on the impact on homelessness and antisocial behaviour. And again, this wasn't sufficiently evidenced. Something which we'll come back to in terms of Great Yarmouth is Fenland District Council tried to rely on a policy and which said that this would cause harm to the local economy. But Mrs. Justice Holgate found that the policy was generally worded, and again, there wasn't the evidence to show that there would be harm to the local economy or the hotel's contribution to the local economy. So again, that's an argument which can work in theory if you have the right policy and if you have the right evidence. But Fenland in this case didn't have either, and so on that basis, the court placed very little weight on that argument. Very little notice was given to Fenland in this case about the housing of the asylum seekers, but because the local planning authority had enough time to assess the use and prepare its case, the court placed no weight on the fact that or very little weight on the fact that the local planning authority had little notice of the housing of the asylum seekers. And so in the end, Mr. Justice Holgate refused the interim injunction. Again, the injunction was not commensurate, that word commensurate, with the level of harm, and there was insufficient evidence. I'll just move on to Great Yarmouth, which is a very specific case, but if you and your authority fall into it, it will be very helpful indeed. So again, it's the familiar factual background of a quia timet interim injunction to restrain a material change of use of a hotel. And the injunction sought by Great Yarmouth was an injunction in relation to the specific hotel, and also every hotel within an area which was protected by a development plan policy. That's policy GY6. And Mr. Justice Knowles granted a without notice interim injunction. And then it came before Mr. Justice Holgate for the on-notice hearing. And the key thing about this case is the policy, is the development plan policy. We know that when one is assessing a material change of use, there are lots of things that can be relevant to the character of the change. One of them is the terms of the development plan. And in Great Yarmouth, obviously it's on the coast, they had a development plan policy which was very specific to a particular area on the seafront. And it was a policy to protect that seafront for the purposes of helping tourism and helping the local economy. And a feature of that policy was to discourage hostels and HMOs and things like that, and to promote hotels where tourists would come and they would stay for a day or a few days or a week, and they would spend money and they would contribute to the local economy. And to Mr. Justice Holgate, unlike in Fenland and unlike in Ipswich, Mr. Justice Holgate found that this was a highly specific protective policy directed at a large and highly important sector of the borough's economy. And unlike tourists, asylum seekers, destitute asylum seekers, are by definition not going to be financially contributing to the economy because they're destitute. And Mr. Justice Holgate said this was a highly relevant factor. So if you're an authority which has one of these policies, and maybe you're by the coast, or maybe you have some other tourist use or town, or some other sort of tourist policy or town centre policy, Great Yarmouth is a case which could be of great use, because if you do have that highly specific, localised protective policy, that can be something you can rely on for saying, well, listen, there has been a material change of use here. And Mr. Justice Holgate was persuaded. He renewed the interim injunctions, relying in large part on that policy, and also coming back to other enforcement measures. An enforcement notice was in place in relation to this particular hotel, dating back from 2006. And so again, going back to what I was saying earlier, if there is if you're taking other enforcement action and it's not discouraging the apprehended breach of planning control, well, that's going to help your case. And it certainly helped Great Yarmouth's case in this instance. Mr. Justice Holgate renewed the interim injunction, not just in relation to this hostel in this hotel, but all of the hotels within the area that was protected by the policy. So all the hotels along the seafront. So just before I pass back to Andrew, sort of overall comparisons, well, they all share sort of broadly similar facts in terms of basic facts, about the hotel facilities not being available to the wider public, the hotel in question not really being physically altered, not really any harm to the environment, to traffic, to the character and appearance of the area. So the basic facts were all very similar. But the details were different, and that explains the differing outcomes in the different cases. All of these cases, Epping and the three that I've just spoken about, they're all interim injunctions. They all apply the same basic principles. So South Bucks, American Cyanamid, the material change of use authorities, which are summarised in Ipswich. They all turned on the balance of convenience that Andrew was talking about. So serious issue to be tried is very unlikely to be in an issue if you were to bring one of these applications. Adequacy of damages, likewise, no cross undertaking needs to be given by the local planning authority. So they're all going to turn on balance of convenience, and that was the case with these four cases. Epping, the difference in Epping is that it wasn't a apprehended breach of planning control or effectively that. There was that sort of background and evidence base which the local planning authority was able to rely on and point to. In all the cases, the court obviously didn't come to a definitive judgment on whether this was a material change of use, although Mr. Justice Eyre was obviously very much persuaded. In all the cases, in any application brought by a local planning authority, you just have to accept that a very weighty factor will be the need and indeed the duty to house asylum seekers. That will always be a very weighty factor against you. The local planning authority, in bringing an application, must itself take this factor into account, the fact that these people do need to be housed and the Secretary of State has a duty to do so. Financial harm is an important factor. In Ipswich and Epping, it attracted great weight because, as Andrew was saying, without these asylum seekers, the hotel effectively wasn't a going concern. But in other cases, that wasn't evidence and that wasn't argued. So if in your application you have a hotel where they're not saying, listen, we're really relying on this, otherwise we're going to go under, in theory, you'd think that would make your case easier. And except in Great Yarmouth, in none of the cases was the breach considered flagrant. So if you're going to be bringing an application as a local planning authority, you're probably not going to be able to rely on the flagrancy of the breach. The reason is because the distinction between hotel and hostel is quite fine, and it's always going to be fairly debatable. So with many Section 187B injunction applications, sort of, people coming onto the land in caravans, it's quite easy. You say this is easily a breach and it's a flagrant one. These applications are not going to be one. It's not going to be in that category. It's always basically, or nearly always, going to be debatable as to whether a breach of planning control has indeed taken place. Great Yarmouth, it was flagrant because of the enforcement notice already in place and because of that restrictive policy. So over to you, Andrew, for the sort of implications going forward for local planning authorities.
For those of you watching, Charles froze momentarily there, but I think he's now handed back to me. Oh, I've got a message saying it's my internet connection, which is unstable. Oh dear, that's on me. I will now very briefly, and I appreciate we've gone a little over time and one or two have got to go to other meetings. I know how tight local authority officer diaries often are. The broader implications of this, well, as we've said on probably more times than we care to remember, these are matters of discretion and are extremely fact sensitive. And Charles has taken us very usefully through some of the differences in the immediate cases that we've seen. Also worth knowing that this is not something which the Court of Appeal has had a say on, either in terms of the substantive issues or the discretionary issues. We think it likely, and I'll come on to the the central government position in a moment, but we think it likely that this one may go up to the Court of Appeal. Given that these are quintessentially matters of judicial discretion in terms of balance of convenience, I think it's quite unlikely that a Court of Appeal would choose to interfere. They usually are very loath to overturn exercises of judicial discretion rather than judicial understanding of the law, but we shall see. Now, the key takeaway for me from the Epping case in terms of moving forward is that the judge was very explicit, first of all, in identifying those three factors: integrity of the system, the deliberate nature of the breach, the strength of the case. Very clear in identifying those as why he decided the balance of convenience in favour of the interim injunction. And they are all things which I've called them transferable, but you would expect, what that means is, you would expect to find those features in a lot, if not most, similar asylum cases. And whilst, as I say, the factual background is of fundamental importance and may change everything, there is a reasonable case for saying that those three factors, transferable as they are, might be applicable in lots of other cases. And I think that is really quite important going forward. The other really important factor that we've identified is the quality of the evidence, the coverage of the issues that it deals with, and the importance of detailed, accurate evidence about all of the effects, because it will be very, very carefully scrutinised. And the final thing to say going forward, and it's one of the odd features of the Epping case, is that the Home Office themselves, albeit at a rather strangely late stage, sought to intervene to give their own submissions to the court. And the court refused, Mr. Justice Eyre refused to allow the Home Office to intervene. And I think there's a reasonable case for saying that the public policy, the wider public policy aspects of what's going to happen if hotels can't be used in this way for accommodating asylum seekers perhaps weren't fully ventilated in the case. The judge gave weight, as I mentioned, to the fact that there was a need to accommodate asylum seekers, but it perhaps didn't get the working over that it might well have done if the Home Office had been present. Now, Stop Press News, I actually heard it on the radio about 15 minutes before we started that. The Home Office have now announced that they are going to be appealing against the refusal of the court to allow them to intervene. I suspect if that appeal is successful, what the Home Office will then be able to do is to make submissions to the Court of Appeal that permission to appeal should be granted. I mean, it's a pretty convoluted legal process, but I think that's what the net consequence would be, so that if this does go to the Court of Appeal, the Home Office will be there to make submissions to the Court of Appeal. May not matter much because of the fact that it's an exercise of judicial discretion that's being examined and the courts don't interfere. But I think what one can say is that the Home Office will be tooling up now to make damn sure that if other injunctions, i.e. ones that might be brought forward by all of your councils, come forward, that they will be there to intervene early enough to get a hearing and to make those public policy arguments. So that may change the balance as we go forward. Now, time is passing. We've overshot, so I'll leave it there. There's just one question. Lots of people have asked for copies of the slides. They'll be provided. We'll try and provide you also with a link to the judgment itself so you can read in detail what we've said. And we've got one live question, which I'll just very briefly deal with, from Robin Levitt, who asks if there's a distinction in principle between the use of a hotel to accommodate asylum seekers and to accommodate the homeless. The answer, I suppose, is that in principle, no, there is no difference. It's a question of whether or not there's been a material change of use away from what one conventionally understand as a hotel use. But these things are so fact sensitive, as we've emphasised, that describing them as matters of principle is a bit dodgy, frankly. And one can easily imagine in terms of public reaction, in terms of the particular conditions under which homeless people might be accommodated, in terms of whether or not a whole hotel unit was taken over to accommodate homeless people, that you would have a completely different set of facts on the all-important factual issues. I don't know if Charles wants to add anything before we go, because I say, well, no, we've gone a little over time.
No, I think just thank you very much, everyone, for tuning in at such short notice, and hope you found it helpful.
Yes, indeed. I would endorse that. Thank you all, and have a good afternoon preparing your injunctions. Cheers now.